Hi, this is Fred Neiman of Hanlon Neiman, a law firm practicing estates, wills, and trusts in all 22 counties of the state of New Jersey. I've talked extensively about estate planning and the use of wills and beneficiary designations in prior videos. Now I want to talk to you about the use of trusts. Many people aren't sure how a trust functions, how it's structured, and why one should use a trust instead of a will. How does a trust fit into one's estate plan? And the answer is fairly simple, but not that simple. Many people think that the use of a trust avoids probate, and that's a good thing. In New Jersey, probate is not particularly difficult unless you own significant assets in many different types of entities. For example, if you are an entrepreneur and own a lot of real estate or business interests, if you have lots of investments in different names of corporations or partnerships or interests, having a trust could be a very effective way to avoid probate. The downside of probate is when you die, your estate is then essentially frozen until your executor is appointed and the executor is given authority to administer the terms of your will. In the interim, what happens to everything that's in your estate? Essentially, it's frozen unless you take prior precautions. To avoid that, one can put everything into a trust, and upon your death, the trust continues to operate through your trustee, and there is no need for probate. So that is a very significant advantage. But if by and large your estate is not complex or is not significant in terms of its valuation, then perhaps a trust is not as important. When you set up a trust, you're essentially creating a new entity. It may require that each year you file a tax return with it. You have to appoint a trustee who is the person who administers the trust, who is responsible for making distributions of income and principal to the beneficiaries. And one point that a lot of folks are not familiar with or don't fully understand is you can become the trustee of your own trust. In other words, I could take my assets, create a trust, name myself as the beneficiary, and also name myself as trustee, and have an alternate or a number of alternate backup trustees in case I become incapacitated or die. That is known as a revocable living trust. Lots of people like that concept. Many people have them in other states where probate is more difficult. And it's something that I've done for a lot of clients who are just set on having a trust of rather than a will. If you're interested in trust, if you want to know what the benefits of a trust are, as well as their disadvantages relative to the use of a will and estate planning, then I want you to contact me at the toll-free number that appears on your screen. Or you can email me at fneiman, N-I-E-M-A-N-N, at hnlawfirm.com. Either way, I look forward to speaking to you real soon.